Good morning, everybody. First of all, apologies that it's been a little while since I've put anything up, but we've been pretty busy in the office. But anyway, back now, and what I want to look at today is a very recent Western Australian Supreme Court decision, Fry versus Keating, which was handed down on the 23rd of April this year, and it looks at the prosecution of two company directors in relation to a workplace fatality. Just to reconfirm, as always, this is a discussion of a general nature about the case and general legal principles and some safety management concepts. Again, it is not legal advice, and if there's anything that comes out of this case that is of concern to you or specific to your operation, then I recommend you go and seek legal advice on the matter or talk to your safety managers about what some of the safety implications might be for your business. Now, factually, the case was actually quite straightforward. It involved workers in a yard lifting a pack of crane components, these bundled crane components. The pack slipped, the load dropped, and an employee was killed. Now, the accident occurred back in 2007. The case first came on for hearing in 2010, and now it's not until April 2013 that it's finally resolved, which is an issue in itself in terms of the management of these types of cases. But in terms of, I guess, chronology, the company and two directors were initially prosecuted in the first instance in the Perth Magistrates Court, and I don't have a link to that decision, I'm sorry. But in the first instance case, the company was convicted and fined $90,000, and the directors were also convicted and received $45,000 each. That case was appealed to a single judge of the West Australian Supreme Court, and there's a link to the appeal case there if you want to have a look at that. They were successful on that appeal. The appeal was, when I say successful, the convictions were upheld, but the fines were reduced. So the company fine was reduced to $70,000 and the directors' fines were reduced to $10,000 each, but the convictions stood. That decision was again appealed, which is the case we're looking at now, to a full court of the Supreme Court, so three judges of the Supreme Court, and again the link is there. And once again, the convictions of both the company and the directors were upheld, and the original fines were restored. So we went back to the $90,000 for the company and $45,000 each for the directors. Just to make a point also, this was not even though it involved directors, it was not a due diligence prosecution. For those of you either outside of Australia who are looking at this or on the East Coast, we've had a long running debate in this country about harmonising our health and safety laws, and one of the elements of the harmonisation of those laws across a whole number of jurisdictions is what's known as the concept of due diligence for company directors. Those requirements have not yet been picked up in Western Australia, and quite frankly there's no sign of if or when they will be. This was a prosecution under the existing provisions, which are section 55(1) of the Occupational Safety and Health Act in Western Australia. Now, in an Australian context, there's nothing particularly novel about these provisions. They're similar to provisions that existed in most jurisdictions before harmonisation. They still exist, I think, in Victoria. They still exist in Western Australia. And fundamentally, what the provisions require is that for a prosecution against a director or company officer to succeed, the prosecution first has to get a successful conviction against the company, and then it has to demonstrate that that same offence occurred with the consent, connivance or neglect of the director, manager, secretary or other company officer of the company. In this case, the decision focused mainly on the concept, or almost exclusively I should say, on the concept of neglect. So the shorthand version, if you like, of the reasoning of the court was that there was an approved method for lifting these loads of crane packs, and that was referred to as method 1. Some of the riggers and workers in the yard used what was described as an unsafe method, which was method 2. There was no factual dispute because method 2 was used. That was why the worker was killed. And there was also, there was some dispute around this, I should say, but certainly the court ended up finding that the company didn't enforce the use of method 1 at all times. Fundamentally underpinning the decision, there were a lot of arguments by the directors that they weren't aware that method 2 was being used, and ultimately the court said, well, your actual state of knowledge wasn't particularly relevant to the concept of neglect. They said that the seeds for the accident were sown by the director's neglect leading up to the accident, leading up to the date of the accident, by failing to ensure that method 1 was always used, and that there were clear and specific instructions to that effect, and that those instructions were enforced. And there was quite a bit of discussion of the factual material that sat behind that finding. We'll have a bit of a look at that in a moment. Now, relevantly, both of the directors who were prosecuted were experienced in the industry, and they were both qualified doggers and riggers. And they were quite closely involved in the day-to-day operations of the business. They weren't remote directors. As an example, and an important example, in 2004, the directors had discussions with the yard supervisor, and in those discussions they decided to use method 1. So effectively, the directors were involved in coming up with the safe system of work. It should be noted here that there was no dispute in the case that method 1 was an inappropriate method, and it was accepted in the hearing that method 1 was an entirely appropriate way to do the work. So there was nothing wrong with the process that had been designed, if you like, the methodology that they had designed. The difficulty, however, and we've seen this in a number of cases that we've looked at in the past, was even though the system said that method 1 was to be used, method 2 was used on a regular basis. The court specifically referred to 5 employees who had been given specific instruction by other dogmen and riggers in the yard, and based on those instructions they'd received, they thought that method 2 was actually the right method to use. So not only was method 2 being used on a regular basis, there was a number of employees who thought that that was actually the right method. It was interesting because the court made the observation that the doggers and riggers were actually competent, but that competence had actually been overridden by directions from other doggers and riggers to use method 2. And we know that that's not uncommon in a workplace, that competent operators come into a workplace, or they go through an induction and training and come onto a workplace, and they get into the actual working environment, and sometimes it is point blank they're told, don't worry about what you've been told, this is the way that we do it here. And reading between the lines, you get a sense of that in this case. In terms of the level of assurance that the directors had that the safe methods were being used, the evidence is a bit sketchy, but there's a number of comments through the various cases that the directors thought the yard supervisor would enforce the use of method 1. And we'll come back and look at that in a little bit more detail as a concept in a moment. Some of the other factors that were referred to, and these, in my view, really go to the breakdown of the safety management system. So, for example, there was an induction process, but not all the workers were inducted, and this included the deceased. There was no consistent system where employees were shown the correct method, and this referred specifically back to the practice of other doggers and riggers telling new employees the method of work to be done, which led in some cases to the establishment of method 2 as the safe system when it wasn't. This was probably not helped by the fact that there was no written procedure for the work, and the court also identified quite clearly that supervision had broken down. They said, as one example, there are 3 or 4 examples they gave, but as one example they said the use of method 2 had actually been reported by the yard supervisor to his supervisor, but nothing more was done about it. Again, very common theme in these safety prosecutions, that where there's a system of work that is prescribed to be in place and that system of work is not followed, then it's a very short step, it's a very easy bow to draw to say, well, supervision was no good. Because if the supervision was effective, the system couldn't have broken down to that extent, because as it got reported, things would have been done about it. So again, nothing surprising really in any of those findings. When the court talked about what was required for a company and its officers to discharge the obligations to provide a safe working environment as far as reasonably practicable. They said that in this case, look, there needed to be supervision of doggers and riggers despite their qualifications to ensure that the correct method was used. Again, a common theme in many safety prosecutions and accidents that we have what we believe to be a competent workforce and we simply rely on them to do things safely. But time and time again we see cases where the courts say that is simply insufficient and there needs to be some process of supervision and assurance to actually know that our workforce is working safely. We can't just assume. And again, I've got some observations about that in terms of what we may need to be looking at and thinking about going forward. When the court looked at this in the specific context of the directors, they basically formed the view that, look, there are only two things that the directors did. One, they gave or were part of this oral decision-making process that method 1 should be used, and then they believed that after they'd made that decision, Mr. Davies would enforce the use of method 1. And fundamentally, the court was saying that was all the directors did. That was as little as they did. And clearly, I think, and I don't think it's too much of a stretch to say, look, more should have been done by way of putting in place processes to enforce the use of method 1 and give people information about the use of method 1. And moreover, there should have been some overarching assurance process that gave the company and the directors some positive assurance that not only were those things actually being done, which they weren't, but that those things that were being done were actually effective to control the risks, and none of that appears to have happened in this case. Now, I've talked before about supervisors in safety and health prosecutions where it's easy for the court to draw an inference when part of the safety management system is actually not being effectively implemented or carried out, and I've talked about this particularly in the context of JHAs. So if the workers are not doing JHAs, it's easy for the court to find that the supervisors aren't doing their job, because if the supervisors were supervising, then we would know that the JHAs weren't being done or they would be enforced. The same sort of logic appears in this case when we talk about the directors, and so the court has said here, look, it's a relatively short step for the inference to be drawn that the directors were being neglectful, particularly if they're intimately involved in the business and ultimately responsible for their safety procedures. So what the court is saying is it's not difficult for the court to find a director has been neglectful if the director is responsible for safety, is involved in the business, and those processes that have been set up to manage safety are not being implemented. We can easily draw an inference that the directors are being neglectful, because if they were properly doing their job and overseeing the system, they would either know that the system was broken or they would have it brought to their attention and they'd be able to do something about it. And the fact that they don't know means that they're not properly overseeing the system, and that gives rise to an inference of neglect. A good way, I think, to capture some of these thoughts is from another case, DPP and Coates Hire. It's a Victorian decision, 2012, so around the same time. The link is there if you want to have a look at it. But again, this idea that we don't discharge our obligations just by creating safe systems of work. We need to ensure that they are actively and positively complied with, and that requires ongoing supervision and monitoring of the workforce to understand that these processes that we have put in place to manage risk are actually being followed. Okay, so how should we understand some of the lessons coming out of this case? Well, the argument runs something like this. As an organisation, you've developed this system for managing your risks. Typically paper-based, typically lots of information, and that's sitting there in someone's office on a shelf or whatever. But the issue that we need to understand is what is actually happening in the workforce, and how big a gap is there between the system as we've written it or the system as we imagine it and the actual work practices that are going on. This is, and I've probably mentioned this before, but this is one of those concepts of the illusion of safety or the gap, and we know that the gap between the safety management system as it is imagined and the gap and what is actually happening on the ground, we know that that's a significant indicator of an organisation that's likely to have accidents. That's what the research tells us. Throwing my lawyer's hat on for a moment, I think we can say that the greater the departure in terms of time and content from the system, then the more likely it is that managers will be found to be wanting. So in other words, if we've got this documented safety management system sitting over here and something significantly different actually happening in practice, and that's been happening for a long time, and it's been happening in relation to important safety matters, then again, it's that short step to say to senior managers and chief executive officers and directors, you were simply not doing your job, because if you had proper oversight of this system, it could not have gotten so broken. And if you look at any of the major inquiries in the last 25 years, from Piper Alpha through to Deepwater Horizon and the Gulf of Mexico stuff, that theme is pretty much constant and underpinning in the cases. And if we look quite specifically at the Keating and Fry case, we can see how that works. Because this failure to use method 1, the fact that they used an unsafe system of work, was not a one-off departure from an otherwise safe system of work. So there was no evidence that suggested this is our safe system for lifting, this is how we enforce it, this is how we know it's done, this is how we know that this is what is used all the time. None of that evidence was there. In fact, the evidence was all the other way. There was no way of enforcing the method, there was no proper induction or training or supervision, and in fact method 2 was regularly used, and some of the workers thought that it was the appropriate method to use. So it was a fundamentally broken system. It was an important departure from the system in terms of both time, in that it had been happening for a long time. Between 2004 and 2007, the court said it had been happening frequently and regularly. So it was a significant departure from the requirements of the safety management system in terms of time, in that it had been going on for a long time, and in terms of content, because this was an important risk. It was a recognised risk. They developed a safe method because they knew that if they lifted these crane components improperly, there could be accidents and ultimately people could die. So we're talking about a significant departure from a proposed safe system of work in terms of both time, in the length that it was going on, and content in the context of the seriousness of the risk that they were trying to manage. Which I think leads quite logically into the question for businesses to take away from these types of cases, and safety managers to take away. Are there any long-term departures from your safety system, from the processes that you have to manage risk, that affect important risks in the business? So if you want to strip that down even more simply, what are the things in your business that could kill people, and how do you know that the controls are in place to effectively manage those? Okay, that's it for now. Here's all the links. If you want to get the case, there's a link there. We've already got some links in the paper already. You can follow the blog, follow me on Twitter, email if you want email alerts and updates, or you can follow our links down there to find out more about us. Got a couple more programs I'll be posting up shortly. In the meantime, appreciate any feedback or comments, and thanks for tuning in. Cheers.